programs and publish editions of works, right? Now, who owns the works by and large? If it is done by an author, the general rule is that the first copyright owner is the author of the work, the person who generates it, if it is an original piece of work, right? If you are under employment, generally, if the work is created in the course of business, let's say you are employed as a scientist, right, or as a programmer to work for a particular company, the software that you develop or the scientific discovery that is made as a result of your employment means that the intellectual property, the copyright, belongs to the employer, not to you, because you're employed for that purpose, right? Likewise, if you commission work, right, the owner of that copyright is the commissioning party. So if I employ you to come and take photos at my birthday function, I'm the copyright owner of the photographs that have been taken, because I've already paid for it. Okay, that is the general principle. How about entrepreneurial works? Entrepreneurial works are things like sound recordings, cinematographic films, and so on. Any sound recordings, the maker of the recording, unless it is done by commission, right? That means if you're the one recording, singing, playing the guitar, whatever, you are the maker of the work, you own it. Filmmakers, same thing, unless you've been commissioned, right? So if MediaCorp commissions you to go and shoot something, of course MediaCorp owns it, right? Broadcast, the holder of the broadcast license or who makes the broadcast. In the case of cable programs, it is the provider of the cable program service, and in the case of published edition of works, the publisher. The reason we want to know who are the owners of all these works is that if we need to use them for any purpose, we need copyright clearance, we got to know who to find. Now, how long is copyright protection in Singapore? For what? By the way, this is a fragment of a music manuscript found in an old attic, believed to be one of the unknown works of Mozart. Obviously, no copyright left there because since 2004, protection for copyright is life of the author or the creator plus 70 years. It used to be plus 50 years. And then we went and signed the FTA with the US, and US pushed it to 70, right? US used to be 50, by the way, right? Until Walt Disney decided that the copyright on Mickey Mouse was running out. It's true, the copyright on Mickey Mouse was running out, and so they pressured Congress to change the copyright law to add another 20 years. So they got another 20 years protection of Mickey Mouse, right? Otherwise there'll be Mickey Mice's over. So it's now 70 years, right? Same thing in Europe now. Up to 20 years ago, the only country in the world that had 70 years, life plus 70 years, was Germany, right? Now the whole EU is 70, US is 70, and then countries like us also, right? Life plus 70. It also applies to authors' works, except for photographs. Photographs, 70 years after first publication, right? Undisclosed works, like this, 70 years after first publication. So possibly, right, if I publish this, then I've got 70 years protection. Sound recordings and films, again, 70 years after the first publication. Sound broadcast, 50 years after broadcast. And published editions, 25 years from date of publication. Right? So these are things that we have to bear in mind. How can you infringe the Copyright Act? Well, the provisions are there in the Act, Section 31, Section 103. Important thing to note that the infringement has taken place in Singapore. Right? It must have a causal connection with the work in question. In other words, it must relate to that work. And infringement must relate to a substantial part of the work. And what is substantial? This is a big problem. Those of us who are always photocopying articles to read and so on, what is substantial? It's always a big problem, right? Very often they'll say, oh, one chapter of a whole book, or no more than 10%. This is the usual principle of not a substantial part of the work. All right. You can have secondary infringement. This is direct, like direct copying. Secondary infringement if you sell, hire, import, or make a copy of an infringing work. Right? That means somebody already went and fake a DVD, and then you go and take this DVD and you go and rip another DVD. That's secondary infringement. Right? Or you take somebody's fake DVD and then not fake, I mean pirated DVD, and then you rent it out. That is secondary infringement. Like I said, the big problem is with the definition of what amounts to a substantial part of a work, and it depends on the nature of the work and the amount copied, but by and large, in Singapore, we tend to take this 10% rule as the norm, right? It is open, of course, to argue that given the nature of the book, it's not possible to just do the 10%, right? If a guy wrote a 400-page book, each chapter there are only 4 chapters, each chapter about 100 pages. I mean, it makes no sense for you to read part of one chapter only, right? So it's arguable that you can photocopy one chapter. I'm not saying that it will fly, but it's arguable, okay? And if you authorize infringement, you could also be guilty of an offense. What are the punishments? Well, first of all, civil action. The copyright owner can take out an injunction against you, can sue you for damages, and order you to deliver up your offending copies. Of course, that the delivery up is only for things that exist physically, such as a whole mountain full of DVDs or something like that, right? If there's not much that way, hard to ask for this. An injunction is an order to stop doing something. The statutory damages, all right? Now, the Act itself actually provides the statutory damages. So for each infringement is $10,000, up to a maximum of $200,000, unless the copyright owner can prove that the losses suffered is more than $200,000. Okay? Pretty tough sometimes. You can be charged under Section 36 for criminal infringement, right? You can be, they can engage lawyers to privately prosecute you, and the penalties are for making, selling, hiring, infringing copies up to $100,000 fine or 5 years jail. Possession, importing infringing copies up to $100,000 fine, 5 years jail, same story. Distributing infringing copies, $50,000 fine, 3 years jail. Performing or screening work without a license for private profit, $20,000 fine, 2 years jail. Quite dramatic, yes.
A question regarding newspaper articles. So if we were to reproduce, say, one article, is that infringement?
One article in...
And put it online?
And put it online. For profit?
No.
Generally no lah. Generally no. But you see, there is a provision that talks about fair use.
Yeah.
And especially if you take an article and you have a comment on it, right? You want to critique. Yes. Then that's regarded as fair use, part and parcel of fair use. Yes.
Sorry. So what about archival? Archiving that, instead of commenting, you're archiving it.
You're archiving
People
it.
do paper cuttings.
Yes, yes.
But now you're doing it online because it's
Right.
digital.
Well, I think the difficulty with the copyright part is that, okay, it's one thing for you to cut a newspaper and keep it, but if all you did was do the same thing, right? You cut that, what you cut, you save that particular HTML page and then you file it away. There's no infringement of copyright. It's for private use, private study, that is all fair use. Private use, private study is fair use. In America, they've actually gone far enough to accept that sometimes where certain books are, for example, not available, copying the whole book is not a violation of copyright at all, because it's not reasonably available at a fair price. It's difficult. Now, by and large, let me just say that notwithstanding all these scary provisions and so on, okay, the copyright owners are not likely to prosecute in many of these instances simply because it is too difficult to do so, right? And unless they can show that you are actually profiteering in some way, right? Chances are there wouldn't be a problem. Now,